Litigation costs are a major concern for any party to litigation, but if you are a defendant to litigation, especially so. The reason for that is that not only might you have to cover the plaintiff's claim, but you will also cover your own costs, but you're potentially open to their litigation costs. So as part of that, what we want to look at is the various options that are available to defendants to protect themselves. So cost protection tools to limit their exposure to the plaintiff's costs. We will look at four main options, the first of which is security for costs. So effectively, a security for costs application is when the defendant will make an application to court for an order for security for costs. If successful, what happens is that the plaintiff must pay a sum into court which acts as security for their costs if the plaintiff is unsuccessful in its claim. The second option that's available are open offers. These are governed by Order 99 of the Rules of the Superior Court. Put simply, a judge, when assessing costs, can take into account any offers that have been made to the plaintiff. As well as that, there is a third option called lodgements and tenders. So basically, these are governed by Order 22 of the Rules of the Superior Court. So a lodgement is when a party pays into court to satisfy a plaintiff's claim. So they pay a certain amount of money in. Certain categories of defendants, let's say insurance companies, are entitled to make a tender offer, which is basically, it has the same effect as a lodgement, but they do not need to make the actual payment into court. If a lodgement or tender is made and the plaintiff does not accept it, and fail to beat the level of that lodgement or tender, the defendant is entitled to its legal costs from the point that the lodgement or tender is made. The final option available are caller bank offers. Caller banks are generally used in the lead up to trial in order to try to put pressure on the other side to settle. They are a very useful tool in that they can be used at different stages, but what you should be wary is that it is ultimately at the discretion of the court whether they will award the costs, be there a caller bank letter or not. When you're drafting these, a person should be wary of that they are clearly setting out the terms. If they are including costs, they set out what those costs are, the level of them, whether they're going to be taxed or agreed. If they are including interest, they need to stipulate what level, the commencement date, the end date. You just need to be detailed on caller bank letters. It is very important to obtain detailed legal advice as to this, and it is very important that your solicitor understands the nature of how these are to be used, but also the strategic benefit in using them.